Hey everyone, so in this video, I'll be talking about the things that you need to know when preparing the best protest letter in a tax assessment process. So the taxpayer can dispute the assessment notice by protesting administratively via written request for reconsideration or re-investigation. A request for reconsideration refers to a plea for re-evaluation of an assessment on the basis of existing records without the need of additional evidence. It may involve both a question of fact or of law or both. Conversely, request for re-investigation refers to a plea of re-evaluation of an assessment on the basis of newly discovered or additional evidence that a taxpayer intends to present in the re-investigation. It may also involve a question of fact or of law or both. Now, it is important that the protest should be done in conformity with Revenue Memorandum Circular Number 39-2013. Otherwise, the protest would be void or without effect. As always, I will link all their videos references in the description below. Now, with regards to where to file the protest, based on RMC number 39-2013, the correct place of filing the protest should only be in the office of who signed the following, which could be the Preliminary Assessment Notice or PAN, Final Assessment Notices, and Formal Letters of Demand. So the venue could be the office of the Regional Director, Assistant Commissioner for Large Taxpayer Service, and Assistant Commissioner for Enforcement Service. It is imperative that the filing of the protest letter should only be done by the taxpayer or its duly authorized representative in person or via registered mail. According to Section 3 of Revenue Regulation 12-99, which is amended by Revenue Regulation 18-2013, it indicates the time on when to file the protest depending on the assessment notice. For a protest or response for a preliminary assessment notice, it should be within 15 calendar days from the receipt of the PAN. For protest for an FLD or FAN, that is a request for re-investigation, it should be done within 30 calendar days from the receipt of the FLD or FAN. Also, the additional or newly discovered evidence must be submitted to the BIR within 60 calendar days from the filing of the request for re-investigation. Conversely, for a protest that is a reconsideration, similar to what was mentioned a while ago with re-investigation, should also be within 30 calendar days from the receipt of the FLD or FAN. Lastly, for final decision on disputed assessment or FDDA for short, which is a petition for reconsideration by the Commissioner of Internal Revenue, it should also be done within 30 calendar days from the receipt of the FDDA. Any audit findings not protested in the protest letter filed will be deemed unprotested. Each audit finding being protested must be supported by factual and legal basis on why such an audit finding is being protested. The protest letter may also be filed against the findings per notice of discrepancy, which is not yet an assessment notice. And to emphasize what I said earlier, file the protest letter to the office of the BIR official who signed the notice that is being protested. And that's it, so I appreciate you watching until this part of this video. If you found this video very helpful, you can watch my other content related to the assessment process. So as always, a huge thanks for watching. Consider subscribing for more, and I'll talk to you in the next one.